This is a great question, and I get this a lot, not just by the general public, but also by people that work for law firms and that work for insurance companies. Now, some of this may just be a theory from me, but nevertheless, it doesn't hurt our client's case, so I might as well just do it anyway. The first thing to understand is that insurance companies evaluate risk. Anytime there's an insurance claim, the insurance company says, okay, how much of a risk is this claim to us? In other words, how much could we potentially have to pay out on this claim? If I tell the insurance company our client's injuries and they are not that significant, what it tells the insurance company is that their risk is very low on that specific claim. Because their risk is very low, they do not prioritize that claim. When an insurance company recognizes that the risk level is very low and that they don't have to prioritize a claim, it is very possible that they could deny liability or part of liability because they know at the end of the day, because the case doesn't have that much value, a law firm may not want to file a lawsuit on that kind of case. How hurt our client is has nothing to do whether an insurance company should accept responsibility for the accident. If they caused the accident, they caused the accident. So I like to get them to say that liability has been fully accepted. We acknowledge that we're at fault for this accident. Great. Once you do that, I'm happy to talk to you about the injuries to a degree, like briefly. Because the other part of this is if I tell the insurance company that our client is having neck pain, but then I get the medical records and it says that our client also had neck and back pain, I don't want to deal with the insurance company calling me out by saying, you said that they only had neck pain, but the records say that they had neck and back pain. So what is it? It gives them an opportunity to muddy the waters, even though it may have just been a genuine mistake. Again, I don't have to go into detail. The only time I have to go into detail is when all the medical treatment has been completed and then we send a demand letter to negotiate a settlement. Other than that, I don't have to tell them anything. So if I don't have to tell them anything, why would I? I don't need to. Now, I respect the insurance adjusters. I have a lot on their plate and I know that they're just trying to document their files most of the time. That's all that it is. But I also have a big plate and I have to prioritize how I spend my time. Hope this video has been educational for you. If you'd like a free case evaluation, feel free to reach out anytime. Text or call 832-925-2030. God bless you and have a good day.